the Board of Pardons and Parole, and I would like this court just to look at my appendix at page 11. If you look at the Board of Pardons and Parole's website, well, this is actually a snapshot of their website. It says, roughly around paragraph 3, that the following crimes are ineligible for parole. So there's this dichotomy between 54-125G and 54-125A, where G says you're eligible and A says you're not eligible. So the Board of Pardons and Parole has thus far failed to even acknowledge that someone convicted of murder could be eligible for parole. Now, this court in Gary Constangaway versus Commissioner of Corrections, 300 Connecticut, 649 at footnote 16, has already found that those convicted of murder are eligible for parole. Likewise, the court Judge Abrams, and I'm just going to, I would like to point this court to my appendix 6. Judge Abrams found that my claim was right, but I had 6 years to a possible triggering event. Well, my position is simple. If my claim is right, then the inquiry ends here. Why? Because you're acknowledging that the crime itself is eligible for parole. And if the crime itself is eligible, then there doesn't seem to, for me, we don't seem to need to go any further than that. Because we know that the 54-125G makes the crime eligible. What the Board of Pardons and Parole seems to be doing is, they're saying that we don't need to discuss this eligibility factor because you're not near 95% yet. So don't worry about this eligibility factor yet. But what does this do for me? What does it do to me? What it actually does is, it says, Mr. Francis, you don't have a right to know what the law is. So declaratory judgment actions mean nothing here because we don't have a right to tell you what the law is, and you don't have a right to know what the law is until you reach a certain point, which I totally disagree with. I believe that I do have a right for the executive, for the Board of Pardons and Parole as an administrative agency to tell me what the law is. I believe that the state of Connecticut owes me a duty to let me know what the laws are. And as a citizen of the state of Connecticut, I should have access to the court in this fashion.
Mr. Francis?
With that being said, I'm sorry, say it again.
Mr. Francis, Justice Story has a question for you.
Please.
You're muted, sir. Justice Story, you're muted. No,
Oh.
Justice Story is.
I was just getting through saying, tell me if you can't hear me, so I was muted. Mr. Francis, this is Justice Gloria, and if you can't hear me, there's a slight echo, so I'll be glad to repeat it. There's representations made in the state's argument about your good time accrual. Can you tell me what the record was before Judge Abrams about what your good time accrual was, or your possible, or what your timesheets are saying as far as when your possible date of finishing your sentences based on good time?
Okay, so at the time, because I was sentenced in 1990, there are two possible scenarios. One is what is called a maximum release date. That means, just for better sense of the word, if I was to get into trouble, become a gang member, or get shipped to Northern, I would stop earning good time, and this would be my maximum release date. And there is another thing called the estimated release date. My estimated release date was 2025. So what Judge Abrams was saying was that this estimated release date is going to get lower, by the way. But he said that the claim itself would not be right until 2023 based on the accrual of 17 days a month and 7 days a week, that I would be eligible around 2023. But here's my position. 95, when it comes to a definite sentence, right? If you look at 54-125G, it talks about 95% of a definite sentence. Now, I think the Board of Pardons and Parole is going to take the position that a definite sentence is a sentence imposed by the court. But we know that can't happen because once the court imposes a sentence, then the Department of Correction essentially takes that sentence and say, well, look, we're going to apply all these things to it based on state statute. So there's no such thing as a court-imposed sentence except for a mandatory minimum sentence, where someone would be given a mandatory sentence that he has to serve 5. Otherwise, once I reach into the Department of Corrections, good time applies.
Mr. Francis,
I hope that answers the question.
what's your legal authority for that position?
Okay, so my legal authority is that courts lose jurisdiction upon sentencing. The only way courts have jurisdiction, the minimum is given to the Department of Corrections. Connecticut General Statutes 18-7, I will start there. Connecticut General Statutes 18-98. Connecticut General Statutes 18-100. And these are all governing good time. They all govern good time. And then you have things like risk reduction earned credits, which don't apply to me.
Right, but what I'm trying to figure out is you are given a sentence by the judge. And the
Right.
judge, why isn't that your definite sentence?
I'm sorry, could you repeat that?
Why isn't that is your definite sentence? The sentence that the
Okay.
court hands down.
Okay, so a definite sentence is 50 years, but what I'm trying to say is that it would be impossible to serve a definite sentence because of all of the good time that happens. In other words, I only can serve a definite sentence if I was to come in here and commit bad acts. So I guess my interpretation, and as I view the law of a definite sentence, is that in which the Department of Corrections interprets it as, because they essentially determine how much time I do. And I want to give you one example. Someone convicted of a simple possession could be given a definite sentence of 5 years. But as soon as they reach to a level 3 or level 2 facility, or any facility, the warden has authority to release the individual out of the prison because it's not a violent crime and it's not an intent to sell crime. And that's just the way the law is. So the court might want the person to serve 5 years, but the warden had discretion for the ultimate release. So the ultimate decision is made by the warden on a drug charge of simple possession.
Justice Mullins?
Mr. Francis, I think I'm following you. I just have a question about the definite sentence. So I'm trying to understand exactly where you're going. If you get 5 years and then you're transferred to another facility, the court gave you 5 years to serve. You get transferred to another facility. That's not a mandatory minimum, so the warden can let you out, right? But,
Okay, now this is. I'm sorry.
But if you have probation, won't you have the remainder of that definite sentence hanging over your head? So if you get 5 from the judge, you serve 2, you get released. If you violate probation, won't you still be looking at 3? So your definite sentence is always 5 years. You may get out early, but won't the sentence always be a definite 5 years? Is that not right?
I would absolutely agree with that, but at the same time, you would still be within the custody of the Department of Corrections. So, I mean, probation technically can't start until after you've finished your whole time anyway. So, the probation factor kind of throws me for a loop. So the probation factor also kind of throws me for a loop. So,
Okay.
but yeah, you're absolutely right. A definite sentence, you're still doing the sentence, but only with a possession case, the warden would have discretion to release that individual. Only for a possession case, though.
Justice Khan?
Good morning, Mr. Francis. My question to you, if you can't hear me, please let me know. My question to you is as follows. Earlier in your argument, I heard you say that currently, as it stands, your eligibility will be around 2025 for release, but that with good time, it could be as early as 2023. And so your point was, I may have a definite sentence, but I could get out earlier based on the various calculations the Department of Corrections can impose. Those being time off for good behavior, not doing, not, as you said, joining a gang in prison or doing anything bad. And so I commend you for doing well, but my question is this. Isn't part of the trial judge's decision that until you're at that point where you can claim that sort of right to, not right, but you can make an argument for release that this issue is not right. Because I'm not suggesting this would happen to you, but in a situation of someone else, if their conduct changed while incarcerated, then the date moves. It's not at an exact date. So how does that impact your ripeness argument?
Okay, so I've been told I have 3 minutes remaining, so I'm going to try to answer this question the best way I can. I haven't been able to articulate my position very well, so I'm going to try to do it this way. If you look at the Board of Pardons and Parole's position, they're saying that the crime itself of murder does not get parole. The only reason why I filed a declaratory judgment was to get the Board of Pardons and Parole to say, oh yeah, you're right, 54125G does allow you to get parole. I wasn't talking about when I can get out, because I'm not concerned about that. I'm concerned about programming. And if I'm not eligible, if they say that my crime is not parole eligible, and I would just like to point this court real quick to the Appeals Appendix 57. If you look at the Appeals Appendix 57, paragraph 3, it says if you have a parole eligible sentence. So when it comes to OAP and getting programs, the only thing that the Board of Pardons and Parole is concerned with is if your sentence itself is parole eligible, if your crime itself is parole eligible. Thus far, no one has admitted that the crime itself is parole eligible. And that's what I wanted this court to determine today, that sole factor. Is murder parole eligible?
I believe Justice Ecker has a question.
Thank you, Chief. Good morning, sir. So, and I want to follow up on exactly that lines. So, it seems like there's two issues here, or at least two issues, only one of which I think is before the court. One is whether you're right or wrong about 54125 what definite sentence means, parole eligibility, and those sort of statutory interpretation issues. That's one question. The other question is ripeness, right? And ripeness is I think, a separate issue. It has to do with whether, there's an impact, whether you being right or wrong makes a difference right now. And your claim, as I understand it, isn't, look, I want to get parole under 50, I want to get parole, or something like that. It's that the being parole eligible or not under that statute affects your eligibility to be in a rehabilitation program. Is that right?
This is correct.
So can you explain just briefly what, and I know your time is up, maybe you'll chew in a little bit by a minute or so to your rebuttal time if you choose to do that. But what impact, direct impact right now in your life are you claiming turns on the Department of Corrections' interpretation of that statute? Why does it matter?
Okay, so
right now.
Okay, so as you said, my time is up, but I would like to go into the time that I already have remaining to answer your question.
You may.
Okay, so the direct impact. In 1967, when they made the Department of Corrections, they understood that from the time that you enter prison, a person should be programmed. You should have all of these different types of programs, and these programs help shape your mind, right? So as Goff would say, if you treat an individual as he is, he will remain as he is. And if you treat him as who he ought to be or could be, he will become that person who he ought to be or could be. So if you wait until a person has only a year left after 29 to 30 years of not doing any programs, it alters the mind, and you're only going to go out there and commit criminal activities. So it hurts me in the sense that if I'm not able to get into these programs and keep my mind occupied and keep educating myself, keep learning what are things that brought me here, then there's a possibility that I can reoffend. And the Department of Corrections should be in a rehabilitation business.
How do we know, sir? How do we know? Can I just interrupt you for a moment to ask?
Sure.
How do we know from the record that you can't get into those programs because of how the Department of Corrections interprets this statute? How do we know that?
Okay, so you're right. It's kind of a fluid situation, right? So I'm going to point you to Appendix 9, which is the only evidence I can give you at this point that's concrete evidence. So I would like to point you to Appendix 9 of the appellant's brief. And at the time, what happened with me was that I applied for anger management, which was a program. And when I applied for it, they told me, hey, look, you don't have a voided parole date or you're not near your end of sentence date, so we're not going to give you this program. Now, I'm not saying I haven't had any programs in the Department of Corrections, but they do not have an obligation to give me anything. And as of right now, they're not giving me anything. Don't get me wrong, I take it upon myself to take other courses, but the Department of Correction itself has an obligation to do these things. And the BOP, in order for anyone convicted of murder, needs to just go ahead and update their website, which is a very simple thing. To say
Let's say, sir, let me interrupt again. Let's say, sir, that you're right on your declaratory judgment on the substance of what that statute means. Let's say you win that case. Does that make you eligible for programs that you're not eligible for right now?
Absolutely. Because then I'm no longer invisible within the Department of Corrections. The Department of Corrections look at me as, right now they look at me as a person that needs to be incapacitated as opposed to rehabilitated. Because the crime itself is, let's just face it, 53A, 54A is one of the worst crimes that a person could commit in the state of Connecticut. So when they look at me as someone that, okay, well, we don't need to rehabilitate this guy. He doesn't get parole. He's not anywhere near his end of sentence, which is actually 2027, as they would look at it. And why should we waste our time with this guy? And my thing is that I am someone that needs to be rehabilitated, that needs to enter back into society with a stable mind, and that is my position. And it only takes one thing to say that 54-125G, although conflicting with 54-125A, makes those convicted of murder parole eligible. And I'll reserve the rest of my time, please.
Thank you, Mr. Francis. You have 11 minutes for rebuttal. If we can just hold for 1 second, the tech people want to try to take care of the background noise. That sounds better so far. Thank you, Mr. Goodall. Are you ready to proceed, counsel?
Yes, Your Honor.
Whenever you're ready.
Thank you, Your Honor. Good morning, Mr. Chief Justice, Associate Justices, and may it please the Court. I'm Assistant Attorney General James Belforti, and I represent the defendants, the Board of Pardon and Parole, and the Department of Correction. The appellate court correctly affirmed the trial court, which properly dismissed plaintiff's declaratory judgment action about his parole eligibility under 54-125G because his claim hinges on two speculative and hypothetical events that have not and will almost certainly never occur. The first is him serving 95% of the, quote, definite sentence imposed, unquote. And second is reaching 6 months or less the expiration of the, quote, maximum term or terms for which such person was sentenced, unquote. Both of these dates are far in the future.
Mr. Belforti, Justice Dory has a question.
Yes.
Good morning.
Good morning.
So if there was no good time, if Mr. Francis hadn't accrued good time, or if good time had been abolished before his crime was committed, would the claim be right in your view?
I think I would change the calculus, Your Honor. I don't know if it would necessarily be right because I don't know if he'd be receiving rec credits. And if depending on the amount of time out we have, I still think it would be speculative enough and hypothetical enough. We're talking about like probably 19 years in the future. So
let me just ask you this. I mean, the question is a general one, as I understand it. It must be one that applies to other offenders. Do folks convicted of the statute that Mr. Francis was convicted of, are they eligible for parole under this new public act? So, in your view, none of those become ripe until when? When they get much closer? Do you have any idea when approximately when they have to get close enough that a court could answer that question?
Well, Your Honor, I think first, I wouldn't concede that the question of ripeness implies that all decisions will ultimately become ripe at some point. Just because something isn't ripe now doesn't mean that it will necessarily one day become ripe. But I would say that in this case, we're so far away, and because of the nature of his earned credits in this case, his claim becomes hypothetical and speculative, which is really the essential thing. So I understand your question, Justice Doria, but I think that when we're determining...
Let me just press you on that for 1 minute, Justice McDonald, if I may. I mean, the Department of Corrections has taken the position, at least on their website, that that this offense is ineligible, and you don't have regs that permit, and as I understand it, the Board of Pardons is not subject to a declaratory ruling, administrative type proceeding. So, are you just saying that nobody gets to test what the law is until somebody gets close enough to a release date? We don't know the answer to that question?
Well, Your Honor, I think that in that situation, we're getting close to the concept of an advisory opinion, because if it doesn't make an impact in any way, and in this case, it seems that there are one of two practical impacts, either the actual release, which I think everyone agrees is very far in the future, or this concept of access to rehabilitative programs. Now, I'll point out that this idea of rehabilitative programs wasn't within the plaintiff's complaint, but when we actually look at his argument and we see how it's kind of morphed over time, first it started as kind of a passing reference in his trial brief to an engineering program at Ashantucket Community College. Then before this court, it became this anger management program. That raises a couple of different issues. First of all, it's just not true that Mr. Francis has not been able to receive any rehabilitative programs. In fact, he's received and completed a number of ones. Secondly, even if that were true, then we're getting into an issue of whether or not his claim is even cognizable in a non-declaratory judgment action. So, for example, I don't think Mr. Francis would be able to go and bring a habeas or a mandamus action or an action for damages or anything like that saying, Department of Correction, you must give me this particular program. You must order me into this program. That wouldn't state a cognizable claim. If he doesn't have a constitutional expectation of that, he doesn't have a statutory expectation of that. So by allowing it to proceed via declaratory judgment act, even if this court were to look beyond the fact that it's not in his complaint, there's really no record of that, then it would essentially be an advisory opinion, which is just, well, tell me what the state of the law is. Why? Because I want to know. Sorry, Justice McDonald.
Just a couple of questions. You said we're not close enough. When would close enough be from you?
I'm sorry, Justice McDonald, I didn't hear the end of that question.
You said that this is just it's not right because it's not close enough in time. When is close enough from the defendant's perspective?
Well, in this case, because of the nature of him earning good time credits, I don't think it will ever be ripe because I think at this point it's so hypothetical and speculative. But in general, sorry, Your Honor.
No, and I got that from I guess I'm wondering in this context where it's a declaratory judgment action, there's always doubt in it. That's what it's for. It's a doubt about the juror relations between parties. So what cases do you have that are specific declaratory judgment actions that say you're not eligible to get a declaratory judgment because it's not right? Specifically in the DJ context.
So I think Milford Power is probably the best case for us because that case deals with the concept of, I believe it was two different power companies. The incident was they had a contract, a transistor or something was destroyed, and the defendant provided notice pursuant to the contract that constituted a force majeure incident that might potentially trigger a change in the amount of money that they would be paid or the amount of time it would take them to satisfy the contract. Now, this court ruled that wasn't right because even though they provided notice under the contract, The actual practical issue was still hypothetical because they hadn't provided notice that they were actually seeking additional money or that they were actually going to take additional time. We can juxtapose, sorry, Aaron.
No, I just want to be clear because I have not read that case and I will. Is that a declaratory judgment action, Keith?
Yeah, yes, Your Honor. Yes, Your Honor. So, and I think Your Honor hits on a good point, which is the issue of there is a tension with declaratory judgment actions about issues in the future. And we see cases from this court, and I believe in Milford Power, it talks about the 1932 case about called Sigel. And that was a case about, I believe, a lessor and a lessee, where there was kind of a guy was leasing a part of a commercial building, and it was destroyed. And the lessee was seeking a declaratory judgment to say, well, if you build this building again, I have the rights to resume this lease. And in that case, the court said, well, yes, that is a properly ripe declaratory judgment action. Now, I would point out that in Milford Power, this court, now, first of all, that was a case from 1932. Milford Power, this court kind of identifies, well, Sigel's got some problems because, one, it's an older case, hasn't really been cited that much, but two, Sigel also holds that there still has to be a practical issue at play. It can't just be hypothetical or speculative.
And on that point, you said Mr. Francis has been admitted into some programs. Because of this issue, has he been denied entrance into any programs?
Not to my knowledge, and the record doesn't reflect that, and it's not in his complaint. I think the specific issue that Mr. Francis hones in on, and again, that was brought up purely before this court. It wasn't before the appellate court. It wasn't before the trial court, and it certainly wasn't his complaint, is this issue of the anger management program. We actually look at the document that Mr. Francis submitted, and then we actually added another copy because it was a little faded. But we see that the reason that he doesn't have the anger management program on his offender accountability plan is because it was removed because he's too far away from his release date, which, as we know, is a moving target. It's moving up and up and up. So at the beginning of this action, I believe it was somewhere in the 2028, 2029. Now his maximum release date is 2027. His estimated release date is 2025, and that is getting closer and closer as we talk.
And my final question is on that issue. I mean, apparently the defendant has been thinking of this issue for several years. It's been on for, 4 or 5 years before the trial court injected this issue of rightness into the case. And so when the trial court injected this issue, I know that there was some written material, but there was no evidentiary hearing where Mr. Mann would be able to put on evidence about programs he was not included in, right? So, I mean, that can help because the trial court injected this years into and never had an evidentiary hearing on it.
I'm sorry, all right. I didn't hear some of the end of it, but what I believe you're asking me was there an evidentiary hearing? And the answer is no, there wasn't. But I think what's important about that is at the time that this was before the trial court, based on his complaint, there's no mention of any rehabilitative programs. At the time, he was simply saying, I want a declaratory judgment action. I want the BOPP to schedule a hearing, and I want it factored into my timesheet. So again, there was nothing about saying, I am being denied this program, and if you were to decide this some other way, it would have a practical impact on me. But again, I think that in this case, that gets into a whole other issue of, is that even redressable? If this court tomorrow were to say, yes, you're right, you are theoretically eligible for parole 20 years in the future, that doesn't put any requirements on the Department of Correction to offer him any rehabilitative programs. I apologize, just. I think you're muted, sir.
Oh, I'm sorry.
All right, once again, I did that. Yeah, sorry, unless I have other questions, unless other panel members have a question, I'm gonna jump in. Yeah, it may be true, Mr. Melforti, that maybe all of his relief is not going to be obtainable, but I mean, what about just knowing what the law is so somebody can plan their life? I mean, you and I as state employees have access to declaratory rulings for things like how my pension is going to function and what's my date of retirement. Maybe those would be appealable to the court, maybe not, I'm not sure. But this gentleman just wants to know, if this statute applies to him or not. Why? I guess I just don't understand why there's a ripeness question, at any time.
Well, Your Honor, I think, again, I'll go back to Milford Power, which I think is probably the best example in that case. That was a similar situation where the plaintiffs were saying, hey, we just want to know so that we can plan our relationship going forward, how we're going to approach this. And in that case, the court said, yes, but it still has to be concrete. It can't simply be hypothetical, because if then we get into the dangers of it just being an advisory opinion.
Well, okay, it would be advisory, although I assume it would be binding if it came from a court or this court on the rest of, folks that this might apply to. But what makes it speculative is the good time issue. If it weren't for good time, which, I imagine that stuff was injected by your office, putting that evidence in, and it's discretionary. So, that's what's speculative, really, is we don't know whether he'll remain, whether that good time could be taken away, or that's not in the record other than you putting it in the record.
Oh, Your Honor, two points on that. First, I would say that his actual estimated release date, or excuse me, his maximum release date, that's something that this court can certainly take judicial notice of. It's something certainly that the trial court could have taken judicial notice of. It's available publicly. It's on the DOC website. That's something that's pretty easy to find. I also don't think that it's an issue in dispute. And we can also concede that it's a moving target. But no matter how we look at this, both parties agree that it's well in advance of the actual triggering mechanisms under the statute. But the second thing I'll say, Your Honor, is to your point about it being speculative about him having it taken away, there would have to be something truly remarkable or dramatic for him to lose banked good time. It's not like rec credits that are completely discretionary. With the good time, you can lose it, and there's a mechanism for that under the statute. But even the Department of Correction, he would have to have a hearing. He would have to forfeit. I believe at this point we're talking 13 or 14 years. It's not even anticipated in the administrative directives that somebody would surrender that much good time at one time. So then he would have to lose it, do something so heinous, probably like a deadly assault, and then lose all that time, then not have it affect his overall sentence, but by, for example, a criminal sentence. And then we're getting to a point where we're speculating that the BOPP would be considering him for parole despite having committed some sort of really heinous crime. I think then we're just piling speculation upon speculation. Whereas the other way we're looking at it, if everything continues to proceed apace, as it has since the beginning of this case back in 2013, before I was even with this office, he's going to be released. So that's, a betting person will put their money that he's going to be released well in advance. So again, obviously we're always talking speculation. I'm sorry, just a second.
No, go ahead and finish. I
No,
just
so-
was raising my hand so that you knew when you were done I had something to ask. Go ahead.
Thank you. No, I was just saying is like, if we're going to engage in, this is the problem, right? If we're going to start engaging in these kinds of speculative acts, this court's decisions do have binding effect. So for Mr. Francis, this is more hypothetical. Well, assuming these very unusual things happen, I would like to know that I'll have this opportunity. But there might be someone sitting in DOC custody right now for whom this decision is really, really important. And that should be determined in the crucible of hot controversy. That should be determined where both sides have to determine.
I'm sorry, Justice Acker, just one quick thing. That's what the declaratory ruling judgment proceeding is all about. You give notice to the class of people that this will all affect, and then you get a decision on the issue. Under your theory, and I know it's not entirely your argument. It's at least partly the trial court. This question may never get answered until somebody is up against a parole date. And Mr. Francis's position is, look, that's way too far down the line to know whether somebody should have been in the pipeline for getting programmed.
Well, again, Your Honor, and I hate to keep going back to this, but he hasn't been denied any programs as a result of this. So that's just not true. And it wasn't in his complaint. and it's just not in the record. So, I mean, if we're going to go outside the complaint, we have to be accurate about what is actually taking place. So again, there are many questions that could be answered by this court that there may never be an answer to, or that, you know, maybe this isn't the right case. But that's why the ripeness doctrine in the context of declaratory judgments is so important, because if it becomes untethered from that, then we're getting really into the realm of advisory opinion. And
Counsel, so just, I mean, I'm trying to do something that's difficult to do, which is imagine myself in the position of a sentenced prisoner, a person like Mr. Francis. You know, shame on me for lack of imagination. It's something I probably should try harder to do. When I do that exercise, though, the first thing I think of is how important it would be to me as a sentenced prisoner to know when I might be eligible to be free, to walk out of prison. That date would be very important to me, I think. And to call it hypothetical and speculative, I don't know, seems to me to ignore that reality. Now it's complicated definitely here by this good time credit issue, you know, because it may be that there's alternative means to release that make this parole eligibility, you know, something that he doesn't ultimately have to rely on. But I would just think that I would be waking up in the morning and thinking, I've got 3,364 days to go. And I just don't get why that's the kind of interest that a person has that we would characterize that as legally unrecognizable.
well, Your Honor, I think in this case, he does know when he's going to be released. He does know when he's eligible to be released. He's pled it. We're talking about it right now. It's probably in 2025. And as time goes on, that date is becoming closer and closer and closer. So I would agree with you, Justice Decker, that if I were, you know, in prison, I too would want to know when I'm getting out. But Mr. Francis does know that. He's known that from the beginning. He's pled that, or excuse me, he's put it in his papers. So, and it's coming up closer and closer and closer. So I don't think he's in that situation, Your Honor, where he is just kind of languishing in a state of ignorance as to when he's being released.
Is that a rightness issue? Is that a rightness problem, though? I mean, maybe you're saying he doesn't have standing, or it's not justiciable for some other reason. But why would that be about rightness? I mean, because the rightness argument is, oh, it's way in the future. It's way in the future, and you're not relying on the future ness of that situation. You're saying it's never going to happen.
So I think, Your Honor, that's true, but that's what was in Milford Power and what this court has said many times, which is if it's contingent on some event that has not and indeed may never transpire. So that is within the ripeness doctrine. But I also think, Your Honor, there are other issues in this case, and that's why we briefed those other issues, which is the whole concept of him having a cognizable claim in a non-declaratory judgment action. So this is, he would not be able to bring a claim saying, I am eligible for parole in 2039. He doesn't have a liberty interest in just eligibility for parole, certainly not under this statute, the way it's worded. He also wouldn't have a cognizable claim saying, I am entitled to particular rehabilitative programs. I want to be in this program, and you have to put me in this program. He would not be able to bring that claim. If he had brought that claim, we would have brought a motion to dismiss, and this would have been a much less complicated issue. And that's what the...
Let me take on your first point, though. I mean, you're probably right about the programs, because that's the second point about DOC. Nobody could compel DOC to provide a particular program. But eligibility for something under a statute, you don't need to have a legal property interest to get a declaratory judgment action that I'm aware of under the case law. You may not have a right to parole, but declaratory judgment actions take place all the time where somebody just says, does this statute apply to me? I don't have a right to anything, but the government has put something in place and I'm interested to know whether I'm eligible. Doesn't that happen all the time?
I think it does happen, Your Honor, but again, I don't think, and that's why I keep going back to that Milford Power case and some of the other cases, is that the concept of ripeness is not incompatible with declaratory judgment actions. And that's kind of the tension that I was talking about between Sigel and Milford Power and some other cases out there where there is a push and pull behind that. And I recognize that, Your Honor. But again, we're talking about something concrete versus hypothetical. If this were having a concrete impact on Mr. Francis, then maybe it would be a different concept in terms of ripeness. I still think he has the other just disability problems that we talked about and that are in my brief, but I could see that. But in this case, because it's so hypothetical, it becomes abstract. And that's what this court needs to, I shouldn't need and doesn't need to, it has guarded against for a long time with declaratory judgment actions, that if you were to allow this to happen, it would just become a vehicle to receive an advisory opinion. And again, Your Honor, I don't want to repeat myself, but I think that that's really the tension going back and forth. But I also say, on the rehabilitative programs issue, I think that's the way we look at this case is impacted necessarily by the nature of the harm. So on the complaint, the nature of the harm seemed to be about being released because he's talking about scheduling a date for eligibility. Now the nature of the harm seems to be, well, I'm not getting rehabilitative programs. And that changes the calculus as well. And if that had been the issue before the trial court, I believe that we probably would have raised the issue of just, I don't know if it would be standing or maybe that I'm using the term redressability. That might not be the proper term. But again, in Milford Power, this court specifically held that there has to be practical relief. Finally, the determination of the controversy must be capable of resulting in practical relief to the complainant. So again, that's probably the more, I guess, applicable issue if we're talking about rehabilitative programs, is that this court, no court would be able to tell the without a constitutional interest or without a statutory interest that he would have to be given a particular rehabilitative program any more than we're able to say you have to be in this prison versus that prison or this cell versus that cell. And again, this is academic because Mr. Francis has received these programs and he's actually earning, in addition to good time credit, he's earning what's called 7-day credit because he has a job, he's a tierman, he's earning the lowest possible sentence possible. So again, we're in the hypothetical realm, and that's why I think that ripeness is a theory here that's important, in addition to those other disability theories I discussed. So, Your Honors, if there are no further questions, I'll briefly conclude. Oh, and I see I have 5 minutes, so that's probably right on time. So, Your Honors, as I was saying before, the whole concept of justiciability, whether it be considered ripeness, mootness, injury, redressability, political question, is that there are certain decisions that the court makes and there are certain decisions that the court doesn't make. And when we're talking about these kinds of determinations that are hypothetical, abstract, prospective, contingent on some event that will almost certainly never happen, then we're removing ourselves from the crucible of hot controversy, which is how we make decisions in our judicial system. We don't just go into court and say, hey, I would like to know this. Now, the declaratory judgment action does allow for that to a certain extent, but this court has set limits to that in cases like Milford Power and in other cases like that. And I think this is just one of those cases. I think that the court properly ruled that it was not ripe. I think this court should affirm both the appellate court and the trial court. And even if this court were determined that that was incorrect, this still lacks justiciability because it's not cognizable in the non-declaratory judgment action. Thank you, Your Honors. Oh.
Counsel, this may not really affect the case in particular, but I'm curious, as you stand here and represent the Board of Pardons and Paroles, isn't there a conflict or some inconsistency with the statute and the website that says murder is not eligible offense for parole?
So, Your Honor, I think the website, that's getting into 54-125A. I'm not sure if it specifically cites that, but that's the statute that it's referring to, 54-125A, because it's talking about the 85% number and it's listing some offenses in there. So it's not going as deep as to say, you know, I also think that there's something to be said for, you know, whether or not the Board of Pardons and Parole's website, which is kind of just like a handy tool for the public, is a definitive statement as to all concepts of law. I mean, in Mr. Francis's complaint, he doesn't say that the BOPP told him, you are ineligible. He simply said, I reached out to them and they never got back to me. So again, I believe it's 125A that they're referring to, Your Honor.
Okay. It should be accurate though, right? I mean, if it's going to be a representation on the website, it should at least be accurate.
I believe so, Your Honor. I wouldn't concede that it's inaccurate. It might be slightly incomplete, but that's, I think, a little different than saying it's inaccurate. And if there are no further questions, that concludes my argument. Thank you, Your Honors.
Thank you very much, counsel. Francis, before you begin your rebuttal, I'm going to need a couple of minutes. I need to reboot my computer. My screen is frozen. So I just need a couple of minutes. I'll be right back on.
Thanks a lot. Okay, I'm back. I can see everyone. Mr. Francis, you have 11 minutes for your rebuttal.
Okay, thank you, Your Honor. I'm very concerned about this case because I believe that it's going to lead to a dangerous precedent. If we're saying that an individual in society doesn't have the right to notice, to know what the law is, then all state agencies can mislead everyone. This can affect public policy in the realm of welfare, recipients, or anyone that just wants to generally know what the law is. They can just basically say, okay, well, this claim is not ripe yet. And I think that this court should find that at the very least, the Board of Pardons and Parole cannot be misleading about what the law is. You can't say this person is not eligible for something and say, oh, well, we don't really mean it that way. If you really dig into it, they are eligible. Why not just say that? You can't have a policy that denies someone something, programs and treatment, and say that, okay, well, we're denying you based on the fact that you don't have a parole date, and we really don't mean that. I mean, that doesn't make any sense to me. And there's a few more things I would like to address. And one of the things is that the Board of Pardons and Parole is saying that I could not have brung this anywhere else except for here. So, but that's not true, because on a mandamus, the purpose of a mandamus is for the court to declare what the law is, but you can't have any other adequate remedy available at law. So technically speaking, I could bring a mandamus if this didn't go through and said, hey, you're a public official, do your job and tell me what the law is, because the legislator has already ruled that 54-125G makes murder parole eligible. So I don't agree with the Board of Pardons and Parole in that sense. Also, I would just like the court to take my pleadings liberally as I'm pro se and read my pleadings liberally, because I'm not an attorney and I'm not skilled at doing this. I put something together the best I can, and there are some things that could have been organized better. But again, I'm pro se and I'm doing the best I can with almost zero resources. The other thing that I would like to bring to the court is that, aside from it being a dangerous situation, when you look at what the OAP says, it says specifically, and again, I'm going to say it again, I know I said it earlier, but it says if you have a parole eligible sentence. So when you're talking about an offender accountability plan, which was created during the Cheshire home invasions to make sure that prisoners were able to attend certain rehabilitative programs because they felt that the two individuals fell through the cracks. It says specifically on the OAP, if you have a parole eligible sentence. If the Board of Pardons and Parole have on their website that murder is not a parole eligible sentence, then why would anyone who assigns programs or has anything to do with programs come and see me? So that's prima facie evidence right there that obviously I'm not getting the program I'm supposed to get. Now, am I saying I get zero programs? No, but any programs I get are from voluntary organizations. Yale Prison Education Initiative has come in and offered programs. Alternative Violence has come in, but these are all nonprofit organizations that have nothing to do with the Department of Corrections. All I'm trying to say is that any Department of Correction programs are being denied to me solely based on the fact that, hey, look, your offense doesn't make you eligible, so we're not going to waste our resources on you. And again, this is a public policy issue. I mean, do we really want to say that we're excluding a group of people solely because of their charge that, as admitted, even though I disagree with the dates, will be released in society very soon? I mean, right now, again, my date is 2020. Sorry. Again, right now, my date is 2025, but sure.
Mr. Francis, let me just ask you specifically, what, from your perspective, what programs have been denied to you as a result of this issue? And was that ever brought before the trial court's attention?
Okay, the program that was denied to me specifically was anger management. And Judge Abrams, I did bring it to Judge Abrams' attention because he asked that we brief on the issue as far as the injury, hypothetical injury. And it was briefed to him. I believe that it's in here, the brief that I put together. If you look at their appendix 27, I address these things. All right. So it's in their brief. Let me make sure so I'm not misspeaking here. Okay, so yes, it is there. This is, if you look at the appendix 27, and this is of the appellee's appendix, I'm sorry, starting at page 27, right?
Right.
The court asked for, the court had scheduled this whole thing for trial. And then what happened was that he said, hey, look, I don't know if this is ripe yet because I didn't think I articulated myself properly. But he said, this claim is not ripe yet. So I would like you guys to brief this thing and determine why and why this court should be considered that it's ripe. And I did that at appellees 27 through 35. All right. So I agree that there are some.
I haven't read that. Do you bring the anger management program that was denied to you? Do you address that in those papers?
Okay, so if you look at the genesis, the easy answer is, I believe I stapled it as an appendix, but the easy answer is this. The genesis of this whole thing started from a grievance that I filed because I did not get anger management. And from there, it morphed into the declaratory judgment. That's the only reason why, thank you. That was the only reason why this whole complaint was brought. But I addressed this to the court in oral argument, and I addressed it, I'm not sure if I put I put Asintuck in here, but I'm not sure I put anger management. And that's why I asked the court to review it as, review my claims liberally. But I made a general broad statement that I was being denied rehabilitative programs because it's not just anger management. It's just the policy itself that is in play. It denies me access to programs, period. That's DOC based. So it wasn't necessarily just anger management. It was any programs that would be foreseen in the future that they're not going to look at. Now, if we were to wait until this claim would be ripe, and just to say, like you said, I would be out of jail before then. But if we either wait till 2023, then what? I would have spent, 6 months programming? That makes no sense. You have to program someone from the beginning to end, and that's why I pointed out that the OAP, which is set up, it was set up for this purpose. And again,
Mr. Francis, may I interrupt for a moment before you change topics? Was there a hearing? There's a reference in Judge Abrams' order to the court scheduling a hearing after briefs. Was there a hearing? I heard you mention oral argument.
Right. To the best of my knowledge, there was a hearing on the motion, which was the motion I'm talking about from 827 to 835. And it was just basically, it was either a hearing or I submitted it on briefs. I think I might have submitted it on briefs. I can't remember. I'm sorry, but I think that
I'm just wondering if there was. I'm wondering if there was a hearing. Sometimes, and I understand that you're self-represented and you're not a lawyer, but you're certainly doing a very good job representing yourself. And if you were a lawyer, I guess what I'd be asking you is whether, sometimes jurisdictional facts are needed. And sometimes those jurisdictional facts are ascertained through an evidentiary hearing. So that, for example, evidence could be heard on ripeness. Let me use that as an example, or some other jurisdictional question. That wasn't done here, I take it. There was no hearing in which, for example, you could offer proof about the impact of your non-eligibility status on your rehabilitative efforts. Is that right?
Yeah, that wasn't done at all. No.
And you didn't now, and I'm not blaming you, but as I understand it, there was a hearing that was mentioned in the order, and then you didn't ask for an evidentiary hearing. The state didn't ask for an evidentiary hearing, and then the judge just went ahead and issued a ruling based on the paper briefs. Is that what happened, to the best of your recollection?
Sure. To the best of my recollection, but what happened was the judge also ruled that let's review this matter back in, I believe it was 2022 or something like that. So it was like a dismissal without prejudice because the judge wanted to basically hear it in 2022 because he felt that the claim would be more ripe by this time. But again, my position is that just as a citizen of the state of Connecticut, I have a right to know what the law is. and that I didn't receive notice of that because of the misleading website, the misleading policies of the Board of Pardons and Parole. And I think that this sets a dangerous precedent and uses ripeness as a way to circumvent the law. I have no audio.
Justice Khan, can you hear us, Mr. Francis?
I can now. Yes, I can
Thank
now.
you.
Yes.
Thank you, Mr. Francis. My question to you is this, sir. If, let's assume the court had not dismissed this for ripeness and your case continued and you got the result that you wanted, which would be that you'd be eligible for release, and parole would not be a basis to deny you any programming. The Department of Corrections could still deny you entry into a program, and there's nothing this court could do, right? Isn't that within their discretion?
Okay, I would say that what I would say is this. Would they be able to deny me? I mean, they would have no reason to. That would be against the administrative policy to deny me entry to a program. But technically, I guess they can do whatever they want to do. They can do that. They can say, okay, well, you're not eligible for any programs. I guess they could, but I don't know under what circumstances that would happen. But because of the trajectory that I'm on, I mean, that wouldn't be something I would really be concerned about. I would have. That's not something I would really be concerned about. But yes, technically speaking, anything could happen like that. It's possible. And I've been told my time is up. Sorry.
Mr. Francis, you can finish that thought.
Okay, so
You gotta wrap this up because parole's calling for this guy. Your time is
okay, I've been told I have to wrap it up because I guess parole is coming in to see someone else now, ironically. But yes, so I would just like to end it there. And again, one of the main issues that I would like to bring to this court is, again, I just feel as a citizen I have a right to know what the law is, and I believe that this ripeness doctrine is in a way to circumvent that. Thank everyone for their time. Please, everyone, stay safe. Have a great day.
Mr. Francis, I want to thank you, and counsel want to thank you. I'm sorry for the technical difficulties, but I just want to thank you all for doing such a great job, especially under the circumstances. Everyone take care. We are in recess.